One of the questions that I receive most often is child support. How on earth is it calculated, and is it going to be different for me than it is for my spouse or for my former spouse or anything in between? So child support in Texas is statutory. The Attorney General's office, through the Texas Family Code, puts together some rules for us to calculate child support. And luckily for all of my clients, it really just comes down to simple math. The way the calculation for child support is done in Texas is we take a party's gross monthly income, and that's inclusive of W-2 wages, bonus, overtime, whatever it may be. And then the Attorney General outlines a handful of deductions that the obligor, the person paying child support, is going to receive from that gross amount. So for example, we take your gross monthly income, whatever dollars you're receiving, and then if you're a payor of child support, you'll get a deduction for federal income tax, you'll get a deduction for Social Security, and you'll get a deduction for Medicare, which is roughly 1.45%. It'll look a little bit different in our calculation than it may look on your normal pay stub. You will also receive a deduction if you are providing health insurance for your children, be it for one child or for 4 children. Whatever it may be, you'll get a dollar for dollar deduction from that amount. You may also receive a deduction for a union due or some sort of mandatory retirement that you don't have any control over, but that's typically done on a case-by-case basis. So after we calculate the various deductions that you may be entitled to, we subtract that amount from the gross monthly wages that you receive, and with that number, we know your net monthly income. The way that the Texas Family Code lines out child support is it divides up how much child support a person's going to pay dependent on how many children both that they have in front of the judge and that they may have that are in a different court case or that they currently have with a new spouse. So for example, if a party has 2 children before the court, but they have 1 child outside of this current case, we take the 2 children and we say, okay, you're gonna pay 25% of your net monthly income, but you are gonna receive a deduction for the 1 child that you have outside of the presence of this court case. And in that instance, you get a slight 2.5% reduction. So when calculating your child support, we would take 25%, get you down to 22.5% of your net monthly income. And whatever that number is, that's what the court is likely to order for your child support. And again, this varies by a case-by-case basis. It's very dependent on whether or not we can calculate properly the amount of income a particular party has. So at the end of the day, child support, albeit just straight math, is still going to come down to reach an agreement or go ask a judge. So oftentimes I'm asked, do we have to do the percentage that Family Code lines out? The answer is absolutely not. Under the assumption that you and your spouse or your soon-to-be ex-spouse, or really just the other parent involved in your court case, are willing to come to an agreement on a number that differs from what we call guideline child support. Ultimately, everybody is hoping to pay the least amount of child support if at all possible. But again, what the court's job is to do is to determine what's in the best interest of the child or children. And the way that the Family Code lines that up is to give you straight guideline numbers with which to work. So if you want to talk more about child support with my office or my team, feel free to give us a call at 817-900-3220 or contact us via our website at familytexas.com.